All right, in week 11, we're going to take a look at statutory and administrative law in Chapter 18. We'll start by looking at the hierarchy of laws in the U.S. The U.S. Constitution is the supreme law of the land. It contains certain powers that go straight to Congress. The rest go to the states. The Constitution, federal laws, and treaties together make up a large body of law in the United States, and in areas where the Constitution gives the federal government the authority, they take precedence. In the area of interstate compacts and uniform laws, the states may not enter into agreements or compacts with other states without congressional consent. Congress has given its consent for states to form cooperative efforts in crime prevention and criminal law enforcement and procedures. An example is the Interstate Agreement on Detainers. One state wants custody of a person being held in another state. A state files a detainer with a custodian holding that person, requesting to be notified before the offender is released. Once the detainer is filed, the holding state or custodian is obliged to notify the requesting state prior to the inmate's release. An inmate may request prompt production for disposition of the charges. If such a request is made, requesting state takes the inmate to the charging jurisdiction. The inmate remains in custody of the sending state during this time, and the sentence continues to run. An inmate must be brought to trial by requesting state within 180 days of the inmate's request. Charges are dismissed if there's no trial by that time, and the inmate is returned to the sending state where he was serving his sentence. The IAD has benefits for both the government and the inmate. It's an easier process for requesting a state to obtain the defendant for prosecution, and it provides the inmate an opportunity to get rid of detainers, the presence of which could affect a current confinement status. Alabama v. Bozeman in 2001 is an example of benefits to the inmate. Bozeman was in a federal prison with state charges. The state officials sought custody of him for arraignment and appointment of counsel. Bozeman was sent to Alabama. He spent a day in court and sent back to federal custody. The following month, he went back to Alabama for trial. The inmate's counsel filed for dismissal under the IAD. The section provided for dismissal of the trial, or if the trial is not held on any indictment, information, or complaint prior to the inmate's return to the original place of confinement. And in this case, that was federal custody. Bozeman was convicted in state, even though the IAD provision had not been met, and the U.S. Supreme Court held that the literal language of the statute was absolute, and the conviction did not stand. In New York v. Hill in 2000, the court approved a waiver of the absolute language. In this case, Hill's counsel agreed at a court hearing to set the trial date to a date outside the 180-day period. The inmate filed for dismissal of the charges prior to trial, but after the 180-day period, the court held this wasn't an issue, that Hill must personally make an informed waiver, adding that his lawyer has and must have full authority to manage the conduct of the trial, and Hill's conviction was upheld. Under the Uniform Criminal Extradition Act, the extradition clause provides that a person who is charged with a crime in one state and who flees to another state must, on demand of the executive authority of the state from which he has fled, be delivered to the state with jurisdiction over the alleged crime. The federal rules are listed here, and the federal government handles requests for returns of persons who fled to a foreign country, and a treaty is needed in those cases. In Collier v. Adams, looking at the IAD and Extradition Act, the court looked at the somewhat competing aspects of these two acts. There's a New Jersey prosecutor under the IAD moved to bring Adams, who was confined in Pennsylvania, to New Jersey for trial. Adams objected, claiming he was entitled to a hearing under the Extradition Act, and the court held the rights and protection of the Extradition Act, specifically the right to a hearing before transfer, were reserved for the prisoner. The Interstate Compact for Transfer of Prisoners, or Interstate Corrections Compact, provides the procedures for transfers of inmates between jurisdictions. The Uniform Act for Out-of-State Parolee Supervision has been enacted in all states. By the Act's terms, parolees must or may go to another state to live with prior permission. Once the transfer is approved, receiving state assumes supervision under conditions set by the sending state. The officers of the sending state may enter the receiving state to retake custody when appropriate, and there's no requirement for formal extradition proceedings. Uniform Juvenile Court Act provides procedures for cooperation between juvenile courts and agencies in different states. The Uniform Victim of Crime Act concerns the victim's rights in criminal justice proceedings and authorizes compensation to victims injured during the commission of crime. It provides for monetary restitution. In the area of state and local laws, regulations, and policies, all levels of government have an executive authority to enforce laws. This could include, depending on the jurisdiction, sheriff, mayors, elected county executives, others. Various types of government overlap and interact in a variety of complex ways. Focus in this section is generalities. There's no one system of state and local government in the United States. There are laws, usually called ordinances, in localities enacted by legislature. At the federal level, agencies may be given authority to adopt rules and regulations. Rules are the detailed laws of most agencies and are considered to have authority in the effect of statutory law. It can be broad or limited, and federal rules are found in the Code of Federal Regulations, or CFR. Most agencies also have internal policies governing their day-to-day operations. And in a lot of cases, these public comments come through publication in the Federal Register. We also need policies to cover personnel, business operations, internal guidance to staff. The chapter covers the Federal Bureau of Prisons created by Congress. They're charged with the safekeeping and care of federal inmates. There's over 100 federal facilities, and this is a while back, 155,000 inmates. It could include detention centers, anything from minimum to high security, penitentiaries, administrative facilities, medical centers, supermax. The BOP legal authorities set forth in 18 U.S.C. The statutes legislate such matters that are listed here, and Congress provides funding for the Bureau of Prisons at the federal level. Bureau of Prison rules are also published in the Federal Register and codified in Title 28. They also publish program statements which provide implementing policies. State and local corrections have same kind of legal framework similar to the BOP. The authorizing statute establishes the agencies. Other statutes authorize the program, activities, and services. At all levels, it's good to invite local and nearby judges and members of their staff to tour the facility. And the chapter wraps up with accreditation. The American Correctional Association is a legal professional association. It has many affiliations. Some are listed here. There's currently 2 levels: mandatory, which requires 100% compliance, and non-mandatory, which requires at least 90%. Right. Here are the steps. There's a desire to be accredited. There's initial review. There's some paperwork that's filed. There's initial pre-audit assessment. There's a self-evaluation. Then there can be an audit externally to verify compliance. These teams review records, first-hand observations. At the close of the audit, the team meets with the warden, goes over the findings. Certificates of accreditation are given to those agencies who meet the standards. It lasts for 3 years. There's requirements for submitting during the time period. There's more than 1,500 correctional facilities and programs involved in accreditation. Approximately 80% of all state correctional agencies and youth services are active participants, as well as the Federal Bureau of Prisons and private sector correction